could get appearances. Now, if I can get appearances from the parties. Do I have a representative from the state?
Sorry about that, Your Honor. I closed the notification and closed my Zoom meeting.
No
Uh,
worries.
Good evening, Your Honor. My name is Daniel Chien, and today I'm joined by my co-counsel, Ms. Disha Vaithianadan,
Good evening, Your Honor.
Good evening.
and we'll be representing the state in today's proceedings. We have a few housekeeping matters we'd like to attend to after the defense's appearances.
Sure, defense.
Yes, Your Honor. Good evening or afternoon, Your Honor. My name is Anya, and today alongside my co-counsel, Ms. Mira Jiang,
Good evening, Your Honor.
we represent the defense of Mr. Nova Wölff.
Good evening, Your Honor.
Good evening, counselors. Good evening, Mr. Wolf. All right, state, you said you had some preliminary matters?
Yes, Your Honor. First, Your Honor, we'd like to invoke Rules 603 and 615, constructively swearing in and sequestering all witnesses and not sequestering party representatives.
Okay, 615 is invoked. Do you have a party representative?
Yes, Your Honor, pursuant to special instruction number 2, we'd like to note that Cotter Ashlock will be our party representative in today's proceedings.
Oh, who is he an officer? Is he,
Cotter Ashlock is the victim of today's case.
and he's a party representative for the state?
Yes, Your Honor. She'll be appearing just at counsel table and able to testify to some of the stuff that happens in openings.
Defense, is that your understanding?
Yes, Your Honor.
Okay, then. Cotter Ashlock will be present throughout trial. Defense, do you have a party or party representative?
We do, Your Honor. Our client, Mr. Nova Wölff.
Perfect. Mr. Wolf will be here throughout trial. Any further matters from the state?
Yes, Your Honor. We'd actually like to note stipulation 7 that exhibits 2, 10, and 12 are pre-admitted at today's trial, only subject to 4.
Yeah, just please bring up at any given time when you're referencing an exhibit that's been stipulated or has stipulations attached to it that it does have stipulations, and we can address it when we get there.
Most certainly, Your Honor. And finally, seeing as this is our first time in Your Honor's virtual courtroom, we'd like to ask your preferences on screen sharing and striking from the record.
So, screen sharing, you don't need to ask for permission. Just be very clear with your narration for the record when something's just being shown to the witness for identification or when you want it shown to the entire jury as well. Just be very clear for those stages and narrate that for the record. As for striking testimony, you should always ask to strike if there was offending testimony, but like don't ask to strike if it was an objection to a question or something like that.
Yes, Your Honor. With that, the prosecution is ready to proceed to opening statements.
Defense?
We have 2 things, Your Honor.
Sure.
First, we'd like to bring the court's attention to case law Tilly versus Swift and Hain, which essentially states that licensed private detectives are not compelled to cease investigations even when instructed by police officers.
Okay.
Next, Your Honor, we'd like to bring the court's attention to stipulation number 10, Cotter Ashlock's parole violation, not to be confused with Your Honorable Judge Ashlock, but it does state that Ashlock pled guilty to violation of release conditions of his parole.
Okay, I understand that's a stipulated fact. If you want the jury to hear it at some point, just make sure that you put it on the record when the record's open.
Yes, Your Honor. And with that, the defense is also ready to go.
Okay, if both parties are good, we'll start with the state's opening statement.
Certainly, Your Honor. May it please the court. It wasn't an investigation. It was retaliation. Your Honor, members of the jury, it's March 11th, around 10:40 p.m. Now, the defendant, Nova Wölff, is standing in his living room on the phone with the police, but in floor down, a former member of the Ashlocks, crime family, sits unconscious, gagged, and tied to a chair. It's a person who is in violation of her parole, a woman named Cotter Ashlock. Now, Nova Wölff knows her. He's been turning in evidence against the Ashlocks for 5 years. But he's not on the phone to turn Miss Ashlock in. because he didn't make that call. The policewoman called him to tell him not to engage with Miss Ashlock in his investigation. Certainly not to arrest her, and certainly not to detain her or interrogate her. That officer tells him to let the police do their job. But instead, you'll hear that he decides he's going to ignore those orders. He's going to ignore his lack of authority, and he's going to interrogate Miss Ashlock. Not to help the police, not to ensure justice, but to further his desire for revenge against a family that killed his friend. That's why he brought 2 charges: unlawful imprisonment and interfering with an officer. As always, those charges come with the burden of proof. We have to prove the defendant guilty beyond a reasonable doubt. While it's a high burden, it's met every day in courts the world over, because it's not beyond a conceivable doubt or beyond a possible doubt, simply beyond a reasonable doubt. We're going to meet that burden through 3 facts: the restraints, the revenge, and the response. So starting with the restraints that unlawfully imprisoned Miss Ashlock, we're going to prove to you today that Miss Ashlock had her wrists tied. You're going to hear from the officer, the defendant, that when they found the victim, she was seated in a chair surrounded by rope fragments. You're going to see a medical record that shows that Miss Ashlock's wrists had rope burns. So second, the revenge. Of course, we have to prove that that imprisonment was unlawful. Since the defendant has no legal authority to arrest people as a private investigator, we expect the defense to tell you that he was performing a citizen's arrest. He must have been trying to help the police apprehend a criminal. Must have handed Miss Ashlock over in reasonable time. But what you'll hear today is that Mr. Ashlock didn't immediately call the police. Instead, he interrogated Miss Ashlock, interrogated her about a murder conducted by one of her relatives. The murder of the defendant's friend. A murder that had decided his actions for the past 5 years. Hunting down the family that killed that friend by any means necessary. Because this wasn't an investigation. It was retaliation. And that leads me to our 3rd fact, the response. Because due to the orders you heard the defendant was under, he interfered with an officer, specifically by resisting. You'll hear from that officer the defendant resisted. You'll see records of the officer commanding the defendant not to circumvent police measures, not to engage with the Ashlocks. You'll see that the defendant was planning on disobeying those orders, because what he wasn't planning was an investigation. He was planning retaliation. So members of the jury, we realize people aren't always good. People aren't always evil. Now, the defendant, he was helping to catch criminals. But when he went outside of the law, he became one. And so I will prove that regardless of the reason, he broke the law. And after we prove that, my co-counsel, Ms. Disha Vaithianadan, will appear before you and remind you that justice for the law and for the people demand you deliver a verdict of guilty. Because this wasn't an investigation. It was retaliation. Thank you.
Thank you, counsel. Can I hear an opening statement from the defense?
Yes, Your Honor. He saw the crime, so he stopped the criminal. It's the night of March 11th, 2025 in Corleone City, and a woman named Cotter Ashlock is lurking in the shadows. Having recently been paroled, Miss Ashlock was not supposed to be in the city of Corleone at all. And she knows that. But she's there anyway, following my client's neighbor. And so when my client, Mr. Wölff, realized what was going on, he knew he had to act. This wasn't an investigation, but it wasn't a retaliation either. It was a citizen's right to uphold justice. Because Mr. Wölff decided to stop a criminal after he saw the crime. Today, by charging my client with kidnapping and interfering with police,
the prosecution has took upon the highest burden of proof in our legal system. The burden to prove beyond a reasonable doubt that Mr. Wölff went against the law to restrain Cotter Ashlock in his home and interfered with the police. Now, as the defense, we understand that by taking on an affirmative defense, we also have a burden. We have to prove to you that it was more likely than not that Mr. Wölff was able to make a reasonable citizen's arrest. And we're going to do that through two key facts. Mr. Wölff saw Ashlock committing a crime, and he stopped the criminal legally. First, Nova Wölff saw the crime. Today, you'll hear from the prosecution's own investigator, Larry Capolino, that Ashlock was on parole and was banned from being in Corleone. And Mr. Wölff saw Ashlock in Corleone. When a felony happens under the nose of a citizen, the law lets that citizen stop the crime. Mr. Wölff had a legal right to stop Ashlock and detain him until the police arrived. And Ashlock wasn't just any parole violator. She was a notorious crime syndicate member lingering around a neighborhood at midnight. And you'll hear from my client's neighbor, Charlie Reeves, about being followed, about being stalked by Ashlock that very night. Mr. Wölff, knowing all of that, knew he had a responsibility to keep Ashlock down and prevent her from escaping and risking the city's safety. Second, he stopped the crime. From the start, Mr. Wölff had a clear intention: to turn Cotter Ashlock over to law enforcement. He didn't take the law into his own hands like the prosecution wants you to believe. He kept a criminal down and called the police as soon as possible, because this was never about retaliation or revenge. He saw a crime, so he stopped the criminal. Now, members of the jury, I want to introduce you to my client. This is Nova Wölff. He's someone with nothing to hide, nothing to lie about. He's not a monster. He's not a kidnapper. And he's here to tell you his side of the story. He saw the crime, so he stopped the criminal. That's why, at the end of today's trial, my co-counsel, Miss Anya will come before you again and ask that you reach the only just verdict. Find Nova Wölff not guilty. Thank you.
Thank you, counsel. Okay. If I could hear from the state, if the state wants to call their first witness.
Yes, Your Honor. The prosecution would like to call Miss Larry Capolino to the stand.
All right, Ms. Capolino, you've been sworn. Counsel for the state, you can proceed whenever you're ready.
Good evening, ma'am. Could you please introduce yourself?
Yeah, sure. Name's Larry Capolino, Inspector, Corleone Police Department.
Well, could you tell us a bit about what you do for a living, Inspector?
Sure, well, I'm a corp, Major Crimes Division, CPD, been doing investigations, organized crime, violent offenses, the kind of stuff nobody wants to touch.
And what got you into this line of work?
Listen, I grew up watching heroes on TV with my grandma, right? Always thought somebody's gotta be the one, keeping people safe. Eventually, I stopped watching the shows and decided to actually be a part of them.
And how long have you worked as an officer?
Gosh, man, over 15 years? 15 years, Over 50 felony investigations, organized crime. I've seen a lot.
Well, why are you here today?
I was the lead investigator. Case involved, the alleged kidnapping and assault of Cotter Ashlock on March 11, 2025.
Well, Let's start where this case started. When did you find out that Miss Ashlock may have been abducted?
Yeah, well, Nova Wölff, called dispatch March 11th around 11:35 p.m., said they were holding a known criminal in their basement. That kind of call, you don't ignore it.
Well, let's see if Miss Ashlock may have been restrained in that basement. Did you find Miss Ashlock at the defendant's house?
Yeah, me and a team who responded basement level, Ashlock, they were bruised, disheveled, sitting in a chair, looked shaken.
Well, were those bruises investigated?
Absolutely, standard procedure. We transported Ashlock back to the station and, sent him to the hospital for a full medical exam.
Inspector, would you recognize the medical report in court today?
Yeah, I would.
Your Honor, stating for the record that the prosecution will be screen sharing what has been previously marked as Exhibit 9. Inspector, could you tell us what's on screen there?
Yeah, that's the medical examinations report of Cotter Ashlock.
Is it a fair and accurate copy?
Yeah, looks so.
The prosecution moves to enter Exhibit 9 into evidence.
Any objections?
No objections, Your Honor. We intend to cross-examine officer on this.
Okay, that's received.
Well, Inspector, could you tell us about the injuries detected on that report?
Yeah, sure. Well, it says right here, Ashlock, was dehydrated, injuries around the knuckles, but the big thing, rope burns around the wrists.
Well, Inspector, is there any record of Miss Ashlock's imprisonment?
Um, yeah, rope fragments around the basement area where Ashlock was held.
And Inspector, does Miss Ashlock have any recording of speaking with the defendant?
Yeah, Ashlock, they managed to record a snippet of their conversation.
Would you recognize the recording in court today?
Yeah, I would.
Stating for the record that the prosecution will be screen sharing what has been pre-marked and pre-admitted as Exhibit 2. Inspector, could you tell us what's on screen here?
Sure. Well, in this recording, this is the recording of Ashlock and Wolf that night.
Were there any statements in that recording that you found especially significant?
Yeah, right there, Ashlock, they asked to be untied.
Well, let's talk about the defendant's response to encountering Miss Ashlock. Now, Inspector, before March 11th, had you talked to the defendant about Miss Ashlock before?
Yeah, a couple days earlier, I called him myself, left a voicemail warning him not to get involved with Ashlock. But, Wolf, Nova didn't answer then, but they called me back later that night.
And does the police department usually record these emergency calls?
Yeah, of course we do.
Would you recognize a transcript of that call if you saw it in court today?
Sure, yeah.
Stating for the record, the prosecution will be screen sharing what has been previously marked as Exhibit 4B. Inspector, could you tell us what's on screen?
Yeah, that's the transcript, the call between Nova Wölff and me.
Is it a fair and accurate representation?
Yeah, looks so.
The prosecution moves to enter Exhibit 4B into evidence.
Any objections?
Yes, Your Honor. We object hearsay specifically to Officer Capellino's statements.
Any statements in particular? Just sort of a blanket objection.
Yes, of hiding things from the police is one such statement.
Okay. Any others?
Not at the moment, Your Honor.
Okay, just so first off, State Counsel, what's the response to hearsay for the you have a habit of hiding things from the police?
Yes, Your Honor. We believe the statements on this transcript are admissible under 8036, records of irregularly conducted activity, as this record was made by both the officer and the defendant who both had knowledge of the events. This course was transcribing these calls and receiving emergency calls is regularly conducted in an emergency department, and Ms. Capolino can testify to these as they were part of her investigation.
Response to 8036.
Yes, Your Honor. In that case, we'd like to have opposing counsel lay all the prongs of 8036 as we believe they are not met.
Okay, I will sustain the objection for now. State Counsel, if you want to try laying a little bit more foundation, and then we can revisit the hearsay after.
Inspector, Inspector, could you tell us, were these calls a part of your investigation, Inspector?
I mean, yeah, it's why I showed up that day. It shows that I told Nova not to show up, not to get involved with the Ashlocks. And well, that's why we're here today. Nova did get involved.
In your other investigations, do you use emergency calls?
Always. I'm a police officer, I'm an inspector, work in the department. It's all we do is, answer emergency calls and record them.
And this call, was it made anytime near March 11th?
Yeah, it was actually on March 11th.
Your Honor, the prosecution moves to enter Exhibit 4B into evidence.
Any objections?
Not at this point, Your Honor.
Okay, 4B will received in full.
Now, Inspector, on that call, what did the defendant tell you?
I repeated my warning, clear as day. And well, Nova, he just says, I don't take orders from you, Inspector. Then, I hear crashing sounds, loud ones, and the line it goes dead.
Well, between that call and when the defendant reported Ashlock, how long was it?
About 45 minutes.
No further questions, Your Honor.
Okay, any cross?
Yes, Your Honor. May I proceed?
You may.
Good evening, Officer Capolino.
How you doing?
I'm good. Thank you for asking. Now let's start with your relationship with Nova Wölff. You've known Mr. Wölff for years, right?
Yeah, help me sometimes with investigating certain people.
Right. He helped give you tips during those investigations, correct?
That's right, gave me tips on the Ashlocks.
And some of those tips had even helped you to arrest those Ashlocks, right?
Yes, ma'am. Some of them, they help me. Others, not so much.
Exactly. Even though some of the tips had helped you arrest criminals, you still don't trust Mr. Wölff, do you?
No, not completely. I can't say I fully trust him.
You don't fully trust him because you think he's reckless, right?
Yeah, I mean, I guess there's other ways you could put it, but yeah, Nova Wölff, they just don't follow orders.
And you think that what Mr. Wölff did was barely even legal, right?
Yeah, that's right.
And so before the March 11th incident, you had already decided that you wanted to arrest Wölff. Isn't that right?
No, ma'am, that's not right.
Is it your sworn testimony today that you didn't already want to arrest Mr. Wölff?
I mean, no, ma'am, I came close because they were drawing that fine line between their own investigation work and my orders. But if you're asking if I had charges against them before, no, I didn't.
Ma'am, I'm not asking if you had charges against Mr. Wolf. I'm asking whether or not you yourself decided that you wanted to arrest Mr. Wolf if you could.
Yeah, ma'am, if I could. I wanted to with the frustration, but I didn't because I didn't have, you know, much evidence yet until tonight.
Right. So let's talk about your investigation on the night of March 11th. Now, when you arrived at Mr. Nova Wölff's home, Ashlock was alive and breathing, correct?
Yeah, they were.
His hands were untied,
Yeah, they were untied.
and Cotter Ashlock told you that she was hit over the head by Mr. Wolff. Isn't that right?
Yeah, they mentioned that, along with a lot of other things Nova did.
And you're aware that Ashlock had a medical examination, isn't that right, officer?
Yeah, that's right, just talked about it.
Now, stating for the record, will now be screen sharing Exhibit 9, the admission report of Cotter Ashlock to the hospital. Ma'am, these are the results of Ashlock's medical exam, correct?
Yeah, ma'am, that's right.
And in this report, nowhere does it say that Ashlock had been hit over the head, does it?
Uh, Guess not, but not a doctor. Ashlock said they were hit in the head. Don't know if it could have left a bruise or not. Can't really tell you that, ma'am.
You don't have to be a doctor to know that on this report it doesn't say that Ashlock was hit over the head, right?
No, according to this report, guess not.
In fact, it does say that there were no contusions to the head were found, right?
Yeah, that's right.
Now let's talk about the forensic evidence. You spoke with Cotter Ashlock after the incident, right?
Yeah, I did.
And Ashlock claimed that Mr. Wolff had interrogated her with a knife, right?
Yeah, it was really heated. Back in New York, I saw all kinds of these things. But the way Ashlock was describing it, man, it scary.
So that's a yes to my question. Ashlock claimed that she was interrogated with a knife.
Yeah, said they were threatened.
And she also said that Mr. Wolff had smashed her phone, right?
Yeah, she brought up that too.
Now, in Mr. Wolff's home, you actually found that knife and phone, didn't you?
That's right, I did.
But what you didn't find was any of Mr. Wolff's fingerprints, correct?
Uh, no, ma'am. If you're asking about the fingerprints on the phone and knife, no, Wolf's wasn't on there.
Right. So the only fingerprints found on the phone that Mr. Wolff allegedly smashed was Ashlock's.
Objection, Your Honor, as to best evidence. May I be heard?
Sure.
Yes, Your Honor. The opposing counsel is going into details found in a forensics report, which is a exhibit found in this case packet. We ask that as they delve into these details, they bring up the evidence.
Sorry, can you remind me what defense counsel's question was?
They asked about fingerprints found on the knife or the phone found in Mr. Nova Wölff's basement.
Response, defense counsel?
Yes, Your Honor. Rule 1002 says that an original copy is required in order to prove the content. But we're not using any reports to prove that there actually weren't fingerprints. We're simply using this to prove that the officer here has knowledge of contradiction with what she was told by Miss Ashlock.
Yeah, I don't believe that defense counsel is trying to prove that these words prove what was the contents of the report. I think they're Okay, so sorry, I started off or something. So defense counsel, can you just explain again what the purpose of this line of questioning is?
Yes, Your Honor. We're not trying to prove that there actually weren't fingerprints on the knife. We're simply trying to show that there exists a contradiction in information that the witness knows from a report versus what she heard from Ashlock.
Response state counsel?
Yes, Your Honor. In that case, we would ask for limiting instruction that these statements not be taken to prove that there were no fingerprints on the phone or knife.
I I'm not going to issue a limiting instruction. I'll overrule the objection.
Yes, Your Honor.
Yes, Your Honor. Now, officer, I'll re-ask my question. The only fingerprints found on the phone that Mr. Wolf allegedly smashed was Ashlock's, right?
Yeah, that's right, but doesn't mean that Nova didn't smash it, could have kicked it out of the hand. Hands couldn't even have touched it.
All right, well, the only fingerprints found on the knife that Mr. Wolf allegedly used was also Ashlock's, right?
Yeah, ma'am, but then again, a knife could have been, placed on the table, threatened that way. Nova couldn't have touched it, but yeah, that's a yes to your question, ma'am.
That's a yes to my question. Now let's talk about what happened to Ashlock after the incident. You didn't charge Ashlock with violating parole that night, did you, officer?
No, it's not really what I do. It's more of the DA's office, but yeah, apparently they got some sort of plea deal.
Right, Cotter Ashlock was offered a full immunity deal, correct?
Yeah, I believe so.
And in that deal, Ashlock has to testify about Nova Wölff kidnapping her. Isn't that right?
Uh, think so. Again, ma'am, DA's office really deals with that stuff. Not too sure of the details.
You're aware of this immunity deal, aren't you, officer?
I know that there is one. Don't really know the terms of it.
Is it your sworn testimony today that you don't know any terms of the immunity deal?
Uh, Ma'am, if you want me to testify to specifically what it says, don't know if I can do that, no.
Ma'am, do you recall writing out a witness statement before trial today?
Yeah, I do.
And do you remember you're sworn in under oath when you were writing that report?
Yeah, I was.
And you remember that you were told to write all the truth and information that are relevant to today's case?
Yes, ma'am, I did.
And you also recall that you were able to edit your report up until today's trial?
Yeah, I was.
Stating for the record, we'll now be screen sharing Officer Capolino's report. Ma'am, is this a fair and accurate copy of your affidavit?
Yeah, seems so, ma'am.
Now, scrolling to the bottom, is this your signature?
Yeah, ma'am, that's my signature.
Now, if co-counsel could scroll to line 101. Please read silently as I read aloud. Ashlock was offered a formal immunity agreement which would exempt him from all the consequences of violating parole allegedly pursuing Jay Kuang. Did I read that right?
Yeah, ma'am, as I said, I know that there was an immunity deal. Don't know what Ashlock had to do to get it.
Objection, Your Honor, as to hearsay 802. May I be heard?
No, overruled.
We can get that screen sharing down, co-counsel. So, officer, you do know that there was an immunity deal agreement.
Yeah, ma'am, as I told you, multiple times, I knew that there was an immunity deal.
And in exchange for that deal, well, Ashlock doesn't need to face any of the consequences of violating parole, right?
Yeah, that's right.
And all he has to do is testify about Nova Wölff's kidnapping.
I think so. I guess, They would have to be truthful when doing so, yeah?
Thank you, officer. Nothing further, Your Honor.
Any redirect?
No redirect, Your Honor. May this witness step down?
Yes. Ms. Capolino, you're excused. Does the state have any other witnesses?
Yes, Your Honor. The state calls Miss Cotter Ashlock to the stand.
Ms. Ashlock, you've been
Issues.
pre-sworn. Counsel, you can proceed whenever you're ready.
Certainly, Your Honor. Good evening, Miss Ashlock.
Good evening.
What do you do for a living?
Well, at the moment, not much, but I might be waiting to get shipped back to prison.
Ma'am, why do you say you might be waiting to get shipped back to prison?
Well, I am Cotter Ashlock, and I've made a bad choice after I got a second chance, and I violated my parole.
Now, Miss Ashlock, I know you're sworn in, but I want you to tell us, are you being complete and truthful today?
Yes, sir. I, I'll be honest. I've lied a lot before. But I've made my choice, and I can assure you that I'm not lying today.
All right then, ma'am. Let's talk about March 11th. Why did you violate your parole?
Well, that day I had gone back to my hometown, and I wanted to get in touch with some of my family. My brother, he would always call them sleeper agents because they used to be in the family, but really they're the guys who had gone out.
Well, ma'am, can you tell us which of those people you were trying to get in touch with?
Yes. Um, well, I was looking for my little brother, Jaden Ashlock. He had gone into the Federal Witness Protection Program, and I just haven't seen him in years.
Ma'am, did you get to see your little brother?
No, and unfortunately not. Um, that day I'd been walking home after trying to search for him. I didn't, but it's so strange. The lady ahead of me bolted.
Ma'am, what do you mean by bolted?
I mean, the guy, sorry, not lady. I apologize, but the guy ahead of me bolted and ran. And he ran up to a house. He knocked on a door. He talked to the guy who answered and ran to the house that was next door.
Well, Miss Ashlock, what happened after the guy ran into the house next door?
It gets a little fuzzy there. I felt something cold and hit my head, the side of my head, I believe. Um, Not like trying to kill me hard, but instead it was like my brain had gotten shaken. And then the next thing I know, I'm waking up tied to a chair with duct tape over my mouth.
Well, ma'am, did you know where you were?
No, not at the time. But later, I did learn that I was in Nova Wölff's basement. The guy who opened the door for the guy who ran.
Well, ma'am, what did you do after you woke up?
Well, after I woke up, I tried stretching out of the ropes with my wrists and tried to slip out.
Did it work?
No, no, um, the chair I was sitting in fell over.
Well, ma'am, what happened after you fell over?
Um, well, Wolf came running down the stairs and he stuffed a phone in his pocket and he righted my chair.
Well, ma'am, what happened after Mr. Wölff righted the chair?
He he began to threaten me with a kitchen knife and that he left on the table and um shined a light in my eyes like it was some kind of interrogation and then after that he tore off the duct tape that was over my mouth and he started to ask me questions.
Ma'am, what kind of questions was Wölff asking you?
Well, Wolf, he started asking about my little brother, Jaden, and I think it's because before he had gone out, um, Jaden had to kill one of.
Your Honor, speculation as to the witness's last statement, if I may be heard.
Sorry, I was muted. I understand the speculation objection. Response, State Counsel.
Yes, Your Honor. Speculation is objection under 602, lack of personal knowledge. We've laid the foundation that this witness has personal knowledge to testify to their rationally based perception here. Specifically, that she knows what Nova Wölff was asking about, and she knows about the related relationship between Nova Wölff and the person he was asking about, Jaden Ashlock. Therefore, Your Honor, it's completely within this witness's rationally based perception to testify as to her reason, her opinion of why Nova Wölff would be asking about Jaden Ashlock.
Response, Defense Counsel.
Yes, Your Honor. While we do agree Miss Ashlock is familiar with Mr. Wölff, there is not nearly enough foundation for her to testify and to speculate that Mr. Wölff was asking questions because of Jay Kuang. We haven't heard anything about how she would be able to reach this conclusion, and nothing about I am here because you killed my best friend and I want revenge against Jay Kuang. We've heard nothing about that. And all of that speculates directly to mindset.
Yeah, Counsel for the State, how is an opinion on why someone might be asking a series of questions, how is that rationally based in the witness's perception?
Your Honor, we have it on a good faith basis that the nature of the way Nova Wölff was asking, that is putting a knife on the table as though it's an interrogation, shining the light in her eyes, she'd then rationally believe that there's something about this interrogation, right? That it is an interrogation and that this guy has something against her. Now, from there, Your Honor, she would have the knowledge that as to what the defendant was asking about and the related connection. It's simply her rationally based perception, her lay witness opinion, and Your Honor, she certified it as an opinion when she said, I think.
I'm going to sustain the objection.
Yes, Your Honor.
Correct, Your Honor?
The offending testimony will be stricken.
Yes, Your Honor.
Your Honor, is that leaving on the record the question about what Wölff was asking about, or is that entire response stricken?
Yeah. This witness can talk about what she was being questioned on, but she can't offer an opinion as to why she thinks the defendant questioned her in this manner.
Understood, Your Honor. Now, ma'am, we heard that the defendant called the police. Did anything else happen before that?
Yes. So this whole time I'm still working at the ropes and I managed to grab my phone, reach my phone and to record the craziness like that he was saying to me, like telling me I can walk out when I was tied up.
Well, ma'am, what else was on that recording?
Um, Not much. I did catch him saying that he wasn't with the police, so it seems like to me, like you guys have been saying, this wasn't an investigation, it was retaliation.
Objection, Your Honor. Speculation to the last part.
Sustained.
Your Honor, oh.
No, sustained.
Yes, Your Honor.
Correct, Your Honor?
Motion granted.
Ma'am, what did you do?
Well, I slipped my hands out and I grabbed the knife that was laid there, and then I cut myself free, and I made a break for it.
Well, ma'am, where did you go next?
I ran outside. And I thought that was obviously the best thing that I could do in that moment. But then, as I was running outside, Wolf called, um, only the guilty run. You will not get away. And honestly, I've heard that many times in the past, but this time I thought, hey, what could I be guilty of?
What do you mean, ma'am?
Well, he kidnapped me, not the other way around. And see now I'm on a plea deal, and that'll get me into a cleaner slate, and that loon is on trial.
Well, ma'am, after you realized that, what did you do?
After I came to my senses, I walked back in. I put down the knife because he started yelling, and I I sat down in the same chair. I answered his questions, and he finally got around to calling the police.
Thank you, ma'am. Your Honor, I have no further questions.
Cross.
Yes, Your Honor. Good evening, Miss Ashlock.
Good evening.
I want to start off by talking about your parole and if Mr. Wölff saw a crime that day. Because you were released from jail on conditional parole.
Yes, ma'am.
That just means you're not allowed to leave your town.
Yes, that's correct.
But on March 11th, 2025, you broke that parole.
Yes, I did.
You left your town and went into Corleone.
Yes, I did. I thought personally it was for a good cause.
You thought it was for a good cause, but that's still against the law.
Yes, I understand that, ma'am.
And while you were breaking the law, you came upon Nova Wölff.
Yes, it was a very interesting interaction.
Well, in other words, Mr. Wölff saw you committing a crime.
He did, yes.
Well, let's turn to your time at Mr. Wölff's residence and address some of the claims you made. Because first things first, you claim you were struck on the head from behind.
Yes, ma'am, but if I can remember clearly, it was not necessarily the back, maybe the side, but yes.
Regardless, you claim you were struck on the head.
That I know of, yes.
A blow so hard that it rendered you unconscious.
Yes, ma'am, I just woke up realizing.
Ma'am, it's fair to say if a blow knocks you unconscious, it would leave some kind of injury.
Well, yes. And
Objection, Your Honor, is to improper expert opinion. May I be heard?
Sure.
Your Honor, to ask this witness to testify as to whether or not a blow was hard enough to leave an injury or not is an expert conclusion that there is no foundation on the record for this witness to have. Your Honor, as far as Exhibit 11, for example, Exhibit 9 goes, that exhibit certifies that the defendant was hit on the head and that blow conflicts with their testimony of being struck. Specifically, they cite contusions. However, Your Honor, to ask this witness about making that kind of an expert conclusion, if injuries such as contusions would be found, or even injuries in general, is beyond this witness's expert opinion.
Response, defense counsel.
Yes, Your Honor. Just for reference, my specific question was, it's fair to say if a blow knocks you unconscious, it would leave some kind of head injury. Your Honor, the question I asked was just calling for common sense. As it is cross-examination, if the witness didn't know, she could have simply answered, I don't know. but it's reasonable for any of us to testify that if you were hit on the arm, it might leave a bruise behind.
Your Honor, if I may be heard.
No need. While I do think that's like a reasonable common sense thing, I think asking this lay witness what someone should expect to see given a type of side effect or injury, I think that delves into territory, so I'll sustain the objection.
Most.
And now, Miss Ashlock, you saw hospital records brought up today.
My hospital records, yes.
Your Honor, for the record, the defense is screen sharing already admitted Exhibit 9.
Sure.
Ma'am, it says right here, no contusions to the head were found.
As it appears so, yes.
You claimed you were hit on the head so hard it knocked you unconscious.
That's correct.
But medical professionals couldn't find anything on your head.
If they couldn't have found anything, then yes, that's correct.
All right, next I want to talk about the knife and the phone you talked a little bit about. Now, ma'am, everything Mr. Wölff touched that day, it would leave fingerprints.
I'm going to re-raise this to improper, or I'm going to object improper expert opinion here, Your Honor.
Yeah,
Your
I'll
Honor.
sustain that.
Yes, Your Honor. Now, ma'am, you're saying he threatened you with a knife that day.
That's correct, ma'am.
He smashed your phone.
Yes, he destroyed my phone, but by stomping on it, yes.
But ma'am, you heard a private investigator, not private investigator, the detective come on stand and say none of his fingerprints were found on those.
Yes, I've heard that.
Mr. Wölff's fingerprints weren't found on that knife he threatened you with.
Objection, Your Honor, to asked and answered. I believe this is the third time.
I'll overrule at this point.
Yes, Your Honor.
Ma'am, Mr. Wölff's fingerprints weren't found on the knife he threatened you with.
No, not on the knife.
Mr. Wölff's fingerprints weren't found on the phone he smashed.
Ma'am, he never smashed my phone. He used his foot to stomp on my phone, so I would assume that there would be no fingerprints.
Regardless, there were no signs that Mr. Wölff touched that phone.
Objection, Your Honor, as to improper expert opinion. May I be heard?
Sure.
Your Honor, this witness can testify to what she's heard, that there were no fingerprints on that phone, but to ask her to use that evidence to thus certify that that means Nova Wölff never touched it would ask her to make an improper expert opinion.
Response, defense counsel.
Your Honor, it's just some phrasing. We believe saying touching and fingerprints is pretty much the same thing.
I'm going to overrule the objection at this point. I just think the witness can say, like, they don't know if they don't know.
Yes, Your Honor.
All right, one more time, Miss Ashlock. Mr. Wölff's fingerprints weren't found on the phone. They weren't found on the knife.
No, I don't really know because I wasn't the one who came up with the results of the fingerprints.
Okay, now let's spend a little bit of time talking about a few facts you brought up in trial. Because you did quote Mr. Wölff quite a few times.
That's correct, yes.
You quoted him telling you, only the guilty run.
Yes, he did yell that behind me.
Specific questions about Jay Kuang.
Jay Kuang? Yes. Or my brother, yes.
He asked you lots of specific questions that you're now telling the court.
That's correct.
Ma'am, this is actually the first time we're hearing of this.
Ma'am, I've only mentioned the things that Mr. Wolf was asking me, but I'm not really sure how to respond to your question.
Ma'am, it's a really simple question. All these specific quotes you listed a few moments ago on direct examination, that is the first time we're hearing it come from your lips. Yes or no?
I guess so.
You guess so. Because previously, you actually spoke with the police several times.
Yes, I have.
They conducted a deposition.
Yes, that's correct.
They interviewed. They spoke with you.
Yes, we had a conversation.
You had multiple opportunities to reach out and explain your side of the story.
Again, it was hard on my end, but yes, technically.
But it is only right now, for the first time in court, we are hearing all of these specific quotes allegedly said by my client. True?
That is correct. I'm here to talk about what has happened on my side.
Nothing further, Your Honor.
Any redirect?
No redirect, Your Honor. We'll let the witness's testimony stand. At this time, the prosecution would like to rest their case in chief. May Ms. Ashlock return to her seat?
Yeah, Ms. Ashlock, you can turn your camera off. Thank you for your time and testimony.
Like I was saying, Your Honor, at this time, the prosecution does rest their case in chief.
Okay. Are we good with a 5-minute recess?
Sounds great, Your Honor.
Okay, we'll be back 30 after the hour. And defense counsel, just so you know, your camera feed was a little choppy towards the end of the cross. So if you want to spend maybe some of this time maybe fixing or adjusting the camera, that might be helpful.
All right, got it. I'll try to troubleshoot the network.
For sure. All right. Be back 30 after the hour. Okay, it's 30 after the hour. Do we have both parties back and ready?
Yes, Your Honor. The defense is all present and ready to proceed.
State?
Your Honor, the prosecution is present and ready to proceed as well.
Okay, let's do this. Last time we were on the record, the defense or the state rested their case in chief. Defense, do you have any witnesses you'd like to call?
We do, Your Honor. We call Charlie Reeves to the stand.
Okay. Mr. Reeves, you've been sworn. Counsel, proceed whenever you're ready.
Yes, Your Honor. Good evening, sir. Could you please introduce yourself to the court?
Good evening. My name is Charlie Reeves.
What do you do for a living, Mr. Reeves?
Well, I used to be a taxi driver, but I've retired now and just want to enjoy my retirement. I wouldn't have survived if it weren't for my mystery novels. I have to recommend The Judas Window. It's an all-time classic.
Well, Mr. Reeves, how did you get involved in today's trial?
I was involved in a crime story of my own. You know, Nova Wölff was my neighbor, so I saw everything that happened. I'm here to tell you what I know.
Well, let's start off with Nova Wölff. You mentioned that he's your neighbor. Are you familiar with him?
Yes, I met him when I moved to Corleone for my retirement. That day I didn't have any sugar, so I asked him for a cup. He tossed me the entire pack.
Was that your only interaction with Mr. Wölff?
No, of course not. In the following days, I often borrowed stuff from him while bringing him extra food I made. He would joke that I was just selling him cookies for the price of sugar and eggs.
Well, were there any other noticeable interactions you had with him?
Nova also told me a lot about Corleone. He told me about this notorious crime family called the Ashlocks. I've always loved detective novels, so it felt like one of them had come to life.
What did he tell you about the Ashlocks?
He talked about how the Ashlocks were lying low and selling sleeper agents where their old base was. Nova's eyes...
Objection, Your Honor. As to hearsay, may I be heard?
No need. I understand the basis. Defense counsel, what's your response?
Our response is, Your Honor, it's not being used for the truth of the matter asserted, but for the effect on Mr. Reeves, if I may proffer.
Sure.
Your Honor, we expect you'll hear in upcoming testimony that the whole reason why Mr. Reeves believed it was an Ashlock member and because he felt like was in danger was because of what he heard from Mr. Wölff in the past, which is why he acted the way he did. It's not for the truth, but the effect.
Your Honor, may I be heard?
Yes.
Yes, Your Honor. Specifically, the testimony about sleeper agents hanging around the Ashlock home base is very potentially prejudicial to our case, given what Miss Ashlock said about why she was in Corleone. And thus, Your Honor, we'd ask for a limiting instruction if they are going to allow this in, especially as they've offered it for a non-truth purpose. Okay,
counsel, would you be amenable to a limiting instruction?
Yes, Your Honor, just saying it's not for the truth.
Okay, yeah, I'll instruct the jury just to take the statements for the effect that it had on the defendant's suspicions of the victim. With that, you can proceed.
Yes, Your Honor. So, Mr. Reeves, can you tell us more about what Mr. Wölff told you?
He told me about these sleeper agents that were hiding where the old base was. Nova's eyes would light up every time he talked about the Ashlocks. It was straight out of a mystery novel.
Did you learn anything else about Mr. Wölff?
You know, I've always loved detective novels, but I never met a real detective. At least not before Nova. You know, he's actually a real private detective. I loved his stories, so I visit him often.
What did he tell you in those stories?
He told me about how one of his friends was killed by the Ashlocks. Nova said that he knew the Ashlocks were behind the murder, and that he would catch them.
Did he tell you how he wanted to catch the Ashlocks?
Yes, he told me about how he works closely with the police. He's actually helped catch many members of the Ashlock crime family, including Cotter Ashlock.
Well, let's shift gears and talk about the day of March 11th, 2025. What happened that night?
I saw someone following me. I couldn't make out their appearance, so I ran to Nova for help.
What did Mr. Wölff do?
Nova told me not to worry about it and to go back home. He looked surprised, almost excited.
So did you go back home?
I did. After I got back home, I tried to calm my nerves. I heard shouting. It was Nova's voice. I wanted to stay home. Despite reading many detective novels, I didn't want to become part of a real case. But curiosity got the better of me.
So, Mr. Reeves, what did you do?
I went downstairs and decided to see what was going on while pretending to water the plants. It was almost like a stakeout.
What did you see?
I saw a figure burst out of Nova's front door, so I ran inside to hide. There, I saw the figure stumbling to the edge of a driveway, panting heavily and catching their breath.
Did you recognize who this figure was?
Under the glow of the streetlight, I recognized the figure as Cotter Ashlock. I was really surprised. I'd seen her on the news and saw that she had been released just a few days earlier.
And what was Cotter Ashlock doing? Could you tell?
She was standing there, motionless. Then she looked back at the house. That's when Nova came out. She didn't approach Ashlock. He just stayed at the door and said something I couldn't hear.
What did you see after that?
Ashlock's eyes flickered. Then she walked right back into Nova's house.
Well, after she walked into Mr. Wölff's home, did anything happen?
I heard voices that were indistinct. Then heard sounds that sounded like a furniture scraping and something being knocked over. Then I heard a loud crash.
Was that the last thing you heard?
No. Then I heard voices yelling at each other. The last thing I heard was Nova yelling something like, "Stop" or "Let go." Then a shrill scream before everything went quiet.
Thank you for your time today, Mr. Reeves. Your Honor, nothing further.
Cross?
Yes, Your Honor. Good evening, Mr. Reeves.
Good evening.
Now, sir, I just finished the Murders in the Rue Morgue. I'd actually like to ask what the title of that book you mentioned at the beginning of your direct was. I'm looking for new. I'm hooked.
It's The Judas Window. It's great. One of the best locked room mysteries out there.
Well, thank you, sir. I'd really love to talk to you about March 11th, if you don't mind.
Sure.
Well, let's talk about when the defendant actually called the police. Now, you said you went to Nova for help when you heard the person you'd later learn was Miss Ashlock, right?
Yes.
And Mr. Wölff said that he would take care of it.
He did.
Sir, to your knowledge, he didn't do that by calling the police, did he?
I don't know.
Well, sir, it wasn't when you heard Nova yell Ashlock that the police arrived, was it?
They didn't.
It wasn't when Miss Ashlock ran away from the defendant's house that the police arrived?
That's right.
Sir, it wasn't until after you heard the sounds of a scuffle that the police came.
Yes.
And sir, you don't know if Nova Wölff waited until then to call them.
I don't know.
Well, sir, let's see if he might have waited as retaliation instead of an investigation. Now, Mr. Wölff is a detective, right?
He is.
He never told you he was in his line of work to help the police, did he?
No, he didn't.
He never told you that he wanted to catch criminals, right?
He did. It was to avenge his friend. He wanted to catch the Ashlocks.
That's right, sir. He told you that he was in his line of work for one reason: revenge.
Yes.
Sorry. Did I lag out? I'm no good with this tech stuff. Can you hear me?
Yes. Sorry, I just didn't realize it was a question. Yes.
Okay. I'm so sorry, sir. Well, let's talk about why he wanted revenge. Now, Mr. Wolf told you that he had a friend, right?
He did.
Like you said on direct examination, he told you that friend had been extorted by the Ashlocks.
Yes. And murdered.
That's right, Cotter Ashlock's family.
That's right.
And he told you that since the Ashlocks murdered his friend, he'd been working to trace them.
Yes. Working with the police.
He told you that he'd been working with the police to trace them for over half a decade of his life.
Yes.
He told you that since then, he'd even moved houses in pursuit of revenge.
Yes, he was dedicated to find justice.
Sir, and you know that the victim of this case is one of those people that the defendant has been pursuing.
I believe so, yes.
Thank you, Mr. Reeves. Your Honor, I have no further questions at this time.
Any redirect?
No redirect, Your Honor. Can Mr. Reeves step down?
He may. Thank you for your time and testimony, Mr. Reeves. Any further witnesses from the defense?
Yes, Your Honor. The defense would now like to call Mr. Nova Wölff to the stand.
Mr. Wolf, you've been sworn. Counsel, you can proceed whenever you're ready.
Yes, Your Honor. Good evening, sir.
Good afternoon, or good evening. The name's Wolf. Nova Wölff.
Where are you from, Mr. Wölff?
Well, I'm a lifelong resident of Corleone City. It's small, real quiet, and close-knit. You know, as I've been living there all my life, I know it like the back of my hand.
Mr. Wölff, what do you do for a living there in Corleone?
Well, I've worked as a private detective for over a decade now. A huge part of the job is this community. That means so much to me.
And why did you choose that line of work?
Well, I had always thought that the justice system worked. That was until a close friend of mine, Mark Volkovic, was killed. I remember feeling so powerless. I became a detective because I didn't want myself or any other families in Corleone to feel that helpless ever again.
I'm sorry for your loss, Mr. Wölff. Now, we've heard a lot about you today, but I'd like to give the members of the jury the chance to hear it from you. Did you try to detain Cotter Ashlock against the law?
Never. In fact, I tried to do the very opposite. I tried to help the police to catch Ashlock.
Now, let's talk about what happened on the night of March 11th, 2025. Where were you that evening?
That evening, I was at my house, finishing up some paperwork, mostly housekeeping stuff. It was pretty late and just another quiet night until I noticed something suspicious.
What did you find suspicious?
Well, the thing that I found suspicious was actually a person. They were normally that would be nothing special, but this person wasn't just passing by. They were outside my window, looking around, lingering. I couldn't see why they were doing that.
Did you find out who that person was?
Yes, I could tell that it was Cotter Ashlock.
How'd you find out it was Cotter Ashlock?
Well, as a detective, I knew her from my work. She's a part of a notorious crime family, and I knew her criminal background. So on that day, I recognized her.
Now, given your work as a detective, did you know anything about Cotter Ashlock's parole conditions at the time?
Yes, I've done my research, and I heard from Officer Capellino. Ashlock was released on parole, and she wasn't supposed to be anywhere near Corleone.
And was anything else out of the ordinary?
Yes, one more thing. My neighbor, Charlie Reeves, he came to my door, and he told me that Ashlock was following him.
What did you do after you heard that Ashlock was following Reeves?
Well, I couldn't ignore a potential crime that was happening right under my nose. Mr. Reeves, you saw him today. He's a good person, but he's getting old. Uh, my job is to keep people like that safe.
Stating for the record will now be screen sharing a visual aid constructively out of view of the jury. Now, Mr. Wölff, did you have a personal reason to detain Ashlock?
Why, yes, I did. She's a member of the notorious Ashlock crime family. I wanted to keep my city safe.
Now, let's talk a bit more about how you restrained Ashlock. Mr. Wölff, after you caught Ashlock, did the police arrive immediately?
No, they didn't. I wish they did. I wish they could have gotten here faster. I don't want a criminal like that in my house. But it took them about an hour, I believe.
You said it took around an hour. Do you know why it took that long for the police to arrive?
I mean, I wasn't keeping track of time exactly, but I didn't call the police until around 11:30 p.m. to let them know that I had Ashlock in my basement.
Was there any reason that you didn't immediately call the police?
Well, I had a criminal to keep down. My very first priority was to make sure that she was fully restrained and not able to escape and hurt anybody. Despite what she said today, she put up a pretty decent fight, and it took me a while to get her restrained.
Did you ever try to hide Ashlock from the police?
Of course not. I like to think that I'm a great detective. But the police are the ones who have their jail cells and their handcuffs, not me.
Mr. Wölff, did you hear your neighbor, Charlie Reeves, testify earlier today?
Mr. Reeves, yes. I was here the whole time. I heard him talking.
Do you also recall Mr. Reeves testifying today that Ashlock had walked out of your house?
Yes, I do.
What was happening then?
Well, Ashlock had tried to leave the house. I said that she could either come back inside or that I'd call the police. And she decided, on her own will, to come back inside.
Do you
Objection, Your Honor,
recall?
as to speculation may be heard.
I understand the objection. Defense counsel response.
Your Honor, we don't believe this is speculation, as Mr. Wölff is simply testifying that Miss Ashlock came back inside after he told her that she could either come back or the police would be called.
Response, City
Response from
Counsel.
Mayor. Yes, Your Honor. We believe that this is delving into the mind of Miss Ashlock because the witness on stand cannot testify using the rationally based perception what effect their words or threats may have had on Miss Ashlock. They already said that they have mentioned police being called, and they don't know what effect this had or if this is her own will to be restrained.
Yeah, defense counsel, how is it not speculation for this witness to say she came back into the house of her own will?
Yes, Your Honor, this is a rationally based perception because it was right after that Mr. Wölff gave the option that Miss Ashlock came back inside. It wasn't that Mr. Wölff forced her to come back inside, rather that well-established fact that Miss Ashlock walked back in on her own 2 feet.
Yeah, I think you can question this witness on whether or not he threatened her to come back inside or physically forced, but I think for this witness to testify that it was of her own free will, I think that is speculative, so I'm going to sustain.
Motion to strike, Your Honor?
Yes, Your Honor.
Yeah, the offending testimony will be stricken.
Yes, Your Honor.
Yes, Your Honor. Now, Mr. Wölff, do you recall Mr. Reeves talking about loud noises coming from your home?
Yes, I also recall that.
And what was the loud noises?
Well, unfortunately, Ashlock didn't comply for long. She was resisting me pretty hard and tried to leave. She was making a big ruckus and knocking some things over in my house.
Did you try to stop her at all?
Of course, I yelled at her to stop resisting and to stay still until the police came to get her.
And were you ever trying to interfere with the police in this process?
No, I never abducted Ashlock. I never imprisoned her illegally, and I never tried to interfere with the officers.
And Mr. Wölff, were you ever trying to retaliate?
No. What I did that night was not retaliation. What I did was for justice. I exercised my rights as a citizen to try to help the police.
Thank you, Mr. Wölff. Nothing further at this time, Your Honor.
Any cross?
Yes, Your Honor. Good evening, Mr. Wölff.
Good evening, counsel.
I want to start with how you know about the Ashlock family.
Sure.
They're a crime syndicate in your area, correct?
Yes, quite infamous one.
And Mr. Wölff, 6 years ago, one of your friends died of poisoning.
Yes, Mark Volkovic. It wasn't just a poisoning, it was a poisoning by the Ashlock family.
Now, that member of the Ashlock family, they pled guilty for that murder, correct?
They did.
But he didn't end up but he didn't end up in prison.
No, I don't believe so.
He never served a second of time.
That is correct.
Now, I want to talk about what happened the next time you met the Ashlocks. Now, on March
Sure.
11th, you saw Miss Cotter Ashlock outside your home.
Yes. Not only did I see her outside my home, I was also informed by my neighbor that she was following him. But by simply being in Corleone City, she was violating her parole.
Now, when you thought she was violating parole, you didn't call the police.
Well, I knew she was violating parole, and no, I did not call the police at that time.
Instead, you restrained her.
Yes, as she was trying to resist, as she was trying to resist me, I did restrain her.
And after you restrained her, that's not when you called the police.
I called the police shortly after I restrained her, yes.
But immediately after, Mr. Wölff, I'm asking you, you did not call the police. Yes or no?
No, not immediately after I got her fully restrained because I was making sure that she could not escape and hurt anyone. But shortly after I did call the police, as soon as I was able to.
Well, let's see if that's true. You would recognize a recording of you speaking with the detained Ashlock.
I didn't record it myself, but sure, I would.
Stating for the record that the prosecution will be screen sharing what has been previously marked and pre-admitted as Exhibit 2. Now, sir, this is that recording, correct?
It appears to be a snippet of the conversation, not the full thing.
That snippet, it's been accurately transcribed.
Yes, it is.
And directing your eyes to the bottom of the screen, it says right there the recording was taken at 11:17 p.m., correct?
11:17 to 11:20 p.m. That is correct.
Now, during that time, Miss Ashlock was in your custody.
She was.
She was speaking with you.
Um, yes, there's a transcript of what she said.
And during that time, Mr. Wolf, you weren't calling the police.
I did not call the police as I was busy restraining Ashlock and making sure that she could not escape. But I did not call the police. That is correct.
Sir, during that time, Miss Ashlock was speaking with you.
Yes, I
She
believe I
wasn't
already answered that.
she wasn't actively fleeing from you.
She was not actively fleeing, but I needed to make sure that she could not flee and could not escape as I called the police.
Now, after that time, 20 minutes after she was restrained and speaking to you, that's when you finally called the police, correct?
And I wouldn't say 20 minutes. It was about 10. This took place at 11:20 and I called them at around 11:30. So I would say about 10, 15 minutes.
Mr. Wolf, when the defendant was restrained and speaking with you, you didn't call the police then.
I didn't. Taking the police, calling the police takes time and my focus away from Ashlock. I could not spare that. I could not risk her escaping and hurting my community.
No further questions, Your Honor.
Okay. Any redirect?
No redirect, Your Honor. May Mr. Wolf step down?
Yeah. Thank you for
The
your
defense
time,
also
Justin.
rests the case in chief.
Okay. Defense rests its case in chief. Do we want to come back like 3 after the hour for closing arguments?
Yes, Your Honor, the prosecution would be fine with that.
Defense, that sound good to you?
Yes, Your Honor.
Okay, we'll be back at 3 after the hour. Okay, it is three after the hour. Are both sides back and ready to proceed?
Yes, Your Honor, the prosecution is ready to proceed.
Defense?
We are as well.
Okay, last time we were on the record, both sides rested and closed the case in chief. State, you can proceed with closing argument whenever you're ready.
Yes, Your Honor. May it please the court. This wasn't an investigation, it was retaliation. Members of the jury, this case was in the making 6 years ago, starting with a man named Mark Volkovic. He was a friend of the defendant, and 6 years ago, he was poisoned. Poisoned by a member of the Ashlock family. And 6 years ago, the defendant decided, and I quote, that he thought that the justice system worked. But when it did no longer, when a member of the Ashlock family walked free after murdering the defendant's friend, he pledged revenge. And on March 11th, 2025, he almost found it when a woman named Cotter Ashlock showed up on his doorstep. He brought Miss Ashlock inside, tied her up, and began an interrogation, all without notifying the police, who were actively investigating Ashlock. That's because this wasn't an investigation, but retaliation. And members of the jury, as the prosecution, it was our job today to prove the defendant guilty beyond a reasonable doubt on 2 charges: unlawful imprisonment and interfering with an officer. What this means is that we need to prove that the defendant restrained and confined Miss Ashlock, and in the process of doing so, he interfered with an official police investigation. But we're not the only ones with the burden today. Today, the defense told you that they would be pursuing an affirmative defense, which means that they have to prove by a preponderance of the evidence, or more likely than not, that the defendant performed a citizen's arrest. And that's what they told you, that he saw the crime, so he stopped the criminal. But members of the jury, he saw a crime, then he committed another one. Because a citizen's arrest is an action to help police investigations. What the defendant did, hiding Miss Ashlock from the police, tying her up and interrogating her, that went beyond a citizen's arrest. And we showed you exactly how today through 3 facts: the restraints, the revenge, and the response. First, we went through the restraints. Miss Ashlock told you about she woke up tied to a chair, duct tape over her mouth. She recorded herself, and you saw that transcript in court today, being interrogated by the defendant, all while being tied up. And on the defendant's direct examination, you heard him say that it was his very first priority to make sure that she was fully restrained. You heard him say that he yelled at her when she tried to escape. You saw Miss Ashlock's medical report detailing rope burns around her wrists, and the investigator in charge of this case told you about rope fragments across the basement. That's because Miss Ashlock wasn't free to leave. And we can see why when we look to the defendant's past, to a friend of theirs named Mark Volkovic, who the defendant told you today was killed at the hands of an Ashlock. With that look, members of the jury, we find why the defendant wanted to seek revenge. And you heard Mr. Reeves on direct examination today saying that Wolf knew the Ashlocks were behind the murder of his friend, and he wanted to catch them. As Mr. Reeves told you today on cross-examination, the defendant wasn't working for justice. He told you that the defendant had moved to Corleone to pursue the Ashlocks, not just to capture criminals. Miss Ashlock wasn't imprisoned for a detective investigation. She was imprisoned for retaliation. And finally, we heard about the defendant's response. Investigator Capolino told you about calling the defendant, telling them to stay away from Miss Ashlock. But you heard in the defendant's cross today that when the defendant had Miss Ashlock captive in his basement, he didn't call the police. In fact, the defendant told Investigator Capolino that he wouldn't follow orders. And during the defendant's cross-examination, you saw proof that Miss Ashlock wasn't resisting. You saw a recording of her speaking with the defendant. The defense told you the defendant is innocent because he did report the crime. But that's not the issue. It's the 20 minutes after the recording Miss Ashlock took of the defendant, the recording where she was restrained and in custody, it's that only after that he called the police. Members of the jury, when a vigilante tries to take justice into their own hands, retaliates without the support of the law, it makes our communities unsafe. When someone can be snatched up off the street, tied up and interrogated, our sidewalks don't seem as welcoming. And for the safety of our homes and our neighborhoods, the prosecution asks you for a verdict of guilty on both counts.
Thank you, counsel. Defense, can I hear a closing argument?
Yes, Your Honor. He saw a crime, so he stopped the criminal. March 11th, 2025. We agree with the state that a crime was committed. We agree that crime should be punished, and that person who did the crime should 100% be held accountable. But that criminal isn't Mr. Wölff. It's Cotter Ashlock, who broke the law, and my client, seeing a dangerous murderer commit a crime, did the only reasonable thing. He stopped the criminal. It wasn't a retaliation, but a result of his investigation. But by coming to court today, the prosecution has taken upon a burden to prove beyond a reasonable doubt that my client committed unlawful imprisonment. And that means there are two things they have to prove: kidnapping and interfering with an officer. Now, this burden isn't an easy one. It is the highest one in the state of Tilly's legal system, and it is so high that if you find a single reasonable doubt, you have to rule in favor of the defense. Now, besides the government's burden, we, the defense today, have also decided to raise an affirmative defense. We didn't have to, but we're confident we can prove more likely than not all the elements to you. Nova Wölff saw a crime, then stopped the criminal using reasonable force. Let's get into it. First, Nova Wölff saw a crime, because that day Cotter Ashlock broke the law. And you don't have to take it from me. Take it from Cotter Ashlock herself. When she admitted on stand, she was released on parole and violated it. Mr. Wölff knew from the detective that this was a crime, and in the interest of the community, he acted on it. So second, my client stopped the criminal. He took the stand himself today and explained his history with the Ashlocks, how dangerous he knows the crime family to be. And after learning Cotter Ashlock might pose a threat to his neighbor on top of already breaking the law, he did what any reasonable detective would do and arrested him. And he did it with reasonable force. Now, we showed you today earlier case law Tilly versus Swift and Heim, and we'll bring it up again. Licensed private detectives do not have to drop their investigations, even if the police tell them so. He did not interfere with the police. What he did do was see a crime. So my client stopped the criminal. Now, the state brought up 3 points today: restraint, revenge, and response, and we agree with most of it. We agree Nova Wölff restrained Cotter Ashlock as a response to seeing a crime. But it wasn't for revenge. Because sure, he had some bad blood, but he was still justified in making that arrest. He didn't break any laws, do any interrogations, but upheld them for the safety of his community. Just like how he vowed to do so when he first became a private detective so many years ago. Now, those 3 points weren't enough for the state to meet their burden. They've got to make it clear, beyond a reasonable doubt, what happened in the basement that night. Now, we have to admit there are only 2 witnesses who can tell us everything. Cotter Ashlock and Mr. Wölff. But I want you to think back to the cross-examination of Miss Ashlock today, when inconsistency after inconsistency was revealed. She claims that she was hit on the head so hard that she was knocked unconscious. But the medical records found no head injuries. Miss Ashlock, she claimed that she was threatened by my client with a knife and even was smashed a phone. The state's own detective admitted the only fingerprints it found on the knife and the phone belonged to Cotter Ashlock herself. Then finally, she started coming up with several incriminating statements my client allegedly made, and despite having numerous opportunities to tell the police, she decides today, in the court of the law, is the first time she would share such important details. That's a witness who's desperate and not telling the truth. But not just Cotter Ashlock, the state's only other witness, the detective, who the both sides should have been able to trust today, was biased and made things up on stand. She admitted that even before this trial and the events of March 11th, she already wanted Nova Wölff arrested. She was looking for an excuse to send an innocent man to jail. Not only that, but that detective further lied on cross-examination when she claimed she didn't know Ashlock's plea deal, then was forced to change her answer when her affidavit was pulled up. Unreliable witnesses. That's not beyond a reasonable doubt. The state proved nothing today. But the defense, our witnesses, clearly told you their story, their testimony that aligned with all the facts. Because Mr. Wölff, my client, clearly explained Cotter Ashlock was fighting, and it took time to restrain her properly. But the minute that was done, the very second, he was immediately on the phone calling the police. He saw a crime and stopped the criminal. That's citizen's arrest. Find him not guilty. Thank you.
Thank you, counsel. According to the defense timekeeper, there's not time left for rebuttal. Does the prosecution timekeeper agree? Okay, got it. Um, in that case, if I could get all the competitors to turn their cameras back on for my judges for the purpose of the uh, outstanding nominations. I think we're waiting on a couple witnesses. Okay, I've submitted my ballot. My score judges can let me know when they have.
I just submitted mine as well. I'm good to go.
I'm also good.
Okay, perfect. William, are we good to go ahead and give comments then?
Yes, thank you.
Okay, perfect. I'll turn it over to my scoring judges first. Ronak, why don't you start us off?
Hi guys, my name is Ronak. I'm a sophomore at the University of Texas. I compete on the Texas mock trial team. I just want to say y'all did a great job. It was a great round to watch. You should be super proud of yourselves. Drew, do you want us to
Yeah,
give
yeah. So
any
I
general
think what they
comments
said
now,
is
or just
do what was a highlight of the round and what's one big picture thing for each side, I think is what they said.
yeah? Honestly, a highlight for me was definitely both teams' integration of theme flips, especially in the opens and the closes. Y'all both teams clearly understood what the other team was saying in terms of the theme, and you flipped them in very interesting and kind of impactful ways, which honestly is better than what we see a lot of times in college. So I was really impressed by that. And then one thing to definitely work on, I think in these objection battles that y'all are getting into, it's sometimes it can be a lot whatever the objection is, and so it's important to really understand the grounds of what the objection is, what the council is specifically arguing, and then respond to what they're saying. So sometimes we're responding to two different things, and it's like two ships passing in the night. So really understanding what the objection is to, and then how to respond to specifically what they're saying, and I think that makes it easier for the judge to rule as well. So, but yeah, I just want to say great job again. It was a great pleasure to judge you guys.
Cool. Aaron?
Yeah, of course. My name's Aaron Sharma. I also compete for UT Austin's mock trial team. I competed all 4 years in high school, but this is my first year on doing college mock trial. I just want to say it was a really good round to watch. I guess my favorite part was closings. I think both attorneys did a really nice job of, I think, really tying together all the evidence we saw. Um, like prosecution, you did a really good job of tying together the defendant's motive to kidnap the victim. I thought you did a nice job of hampering on what the fact that he wanted revenge for his dead friend. And then defense, you did a really nice job of tying back that this was actually just a case of security and keeping the community safe. So I think the closings was definitely my favorite part of trial. I think one big picture thing that I think just looking out for is witnesses on cross. I think there's definitely certain points that y'all get your little back and forth with the facts that you want in and out, but I think sometimes, especially with like bias or like other bad facts, it's better to just agree and not try to fight too much because otherwise it draws too much attention and it can hurt your credibility. But otherwise, great job. I really enjoyed watching everyone today.
Cool. Then I'll go ahead. My name is Drew Ashlock. I am currently a second year law student at the University of Texas School of Law. I compete for our trial advocacy team. Before that, I competed for UCLA for 4 years. Ian was my coach, so you guys see a whole lot of him. And I also now help coach the undergraduate team at UT. So you were judged by me and two of my students tonight, which is fun. Um, Highlight of the round is I think it's very common in mock trial rounds to for people to have sort of the mock scent and talk very mocky and over dramatize things. I think for the most part, people did a really good job just being like very conversational and casual. And I think that was really highlighted from everyone involved in the direct, in the cross, in the witness of the character witness on defense, the Charlie Reeves. I thought the conversation, the back and forth was very natural and just conversational between the attorney and witness. And then I loved on cross how this is not a witness you have to be confrontational with. This person doesn't have a stake in the game. They're not your enemy. And so you weren't very aggressive or confrontational with the witness. It was a very casual conversation, which is fitting for the cross-examination of a witness that you don't have any reason to have an issue with. Like he's just an eyewitness. He's just there. So I thought that was effective. Big picture highlight thing for both teams in case you guys move on and also just for future reference. For prosecution, if the revenge is going to be a big part of the fact structure and it is going to be a big part of the theme, it has to be a bigger part of the case. Just the amount of screen time the revenge motive gets during the direct examinations is lacking. I honestly heard more about this idea that this guy wants revenge. Like, I heard more about sort of this beef that the defendant has with the Ashlock crime family from both of the defense's witnesses than I did from y'all's. Which is which ordinarily might be fine if that isn't a big part of your case theory and theme, but it was. Like revenge was a big part of the theme, and I don't know this fact pattern very well, so I don't know how much you can get from these witnesses. But if revenge is going to be part of your theme, it should be more of the directs. For defense, for my attorneys, um, judges a lot of times will tell you what they want and will be very explicit with their expectations. And both defense attorneys, there were times in this trial where I sustained an objection against you, or I made some comment in an objection argument where I was like, okay, you can't do this, but you can do that. Like, I'm not going to let you ask about this, but you can ask the witness about that. And that was me teeing up, being like, listen, the way you're asking the testimony right now, or the way your witness is saying it right now is inadmissible. But if you just rephrase slightly, you can get it in. And the approach after that should not be, well, let me just move on to my next point. It should be the judge is giving me a pathway to get this evidence in. Let me make the adaptation that the judge is asking for. So make sure you're listening to sort of the comments that a presiding judge gives you after an objection is sustained or overruled, because it'll tell you how you can adapt. And you are you're not like you're less likely to get dinged on a ballot for getting an objection sustained against you, because real attorneys get objections sustained against them all the time. And you might just like have to try and do something that is objectionable. But I think you're more likely to get dinged on a ballot if the judge gives you an instruction to do something and you don't do it. Yeah. Um, those are comments. I don't know if we're open to questions or if William, you're going to give him the results. I don't know if we should give more comments right now. What should we do, William?
We're still calculating the results. They should be in like 2 minutes. So please feel free to give more comments or answer any questions. Thank you.
Sure.
I do have one thing if that's okay, Drew.
Yeah, go ahead, Ronak.
Yeah, so kind of on the note that Drew was talking about with for prosecution revenge, when you guys tee up your theme involving, retaliation, and then a lot of the time, you talk about that in trial or in the defense case, or in the prosecution case, you're using the word revenge. I think if you can mirror what you're saying in your theme in the case as well, and you kind of keep that progression throughout the entire case, it keeps the jury thinking about your theme and thinking about your message overall. And I think the same thing can go for the defense team as well, to integrate your themes and your overall messages throughout the case more in your defense, in your directs and your crosses, to kind of tie everything together, because then we're not waiting until closings to understand where all the pieces of the puzzle fit in, because you've been guiding us through that with the use of your theme and with the use of the fact structure that you mentioned in your openings, throughout the rest of the trial. So that kind of continuity can really help us judges when we're trying to understand the case, as well.
Uh, Also, just a thought that came up. Defense, I think it's important somewhere for y'all to enter an exhibit. I understand that there might not be like great exhibits for your case, but like that's just such an easy thing for judges to be like, oh, they showed me they know the procedure for entering exhibits or for offering evidence. And like there are two things that a mock trial judge is scoring on at any given moment. One is like your performative capability. Are you persuasive? Are you convincing me of your side? And the other is, do you know how to do this courtroom stuff? Like, do you know how to raise an objection? Do you know how to enter a piece of evidence? Do you know how to, ask the leading questions on cross? And so it's important that you check all of those boxes and show that you know the variety of skills that you can showcase. Any other, do you guys have any questions for us? Yeah, Daniel?
Yeah. First question I wanted to ask is for advice on that direct examination. There are a few things that stuck out to me about it that I would ask about specifically, but if you guys have anything you recall right now, I'd love to get specific comments on that particular exam.
To me, the biggest comment is it's just info dumpy right now. And this is a good overall comment for everyone. The fact pattern is complex and the charge is complex, and you guys have a short period of time. So find the extraneous details that aren't that important to your narrative and cut them. And also cut down on names whenever you can. Stop, like, don't give me proper names, give me titles. It's not like blah blah, like it's not like so and so, it's the cousin. Like that'd be a lot more helpful. Okay, William, I take it back on camera. You got results?
Yes. Hi, everyone. Thank you so much for your patience. Again, I'm William. I'm a student at U Chicago. I'm currently a fourth year. And I just want to say before we announce results, a really big thank you to Drew, Aaron, and Ronak for volunteering your time tonight. We at IMT really, really appreciate you being here. And honestly, this round and this tournament would not be possible without your support. So thank you. And congratulations to both teams for making it to the semifinals. We saw some really strong advocacy tonight and great performances. I'm really impressed, and I cannot believe that you guys are just high school students. So now I'm going to start with the MVP witness for this round. That goes to Charlie Reeves, who plays Tobin Hill. Congratulations, Charlie. And next, the MVP attorney for this round goes to Anya Law. Congratulations to Anya. And for both Charlie and Anya, it's an unanimous first rank from all three judges. So really, really impressive. Congratulations. And finally, we'll move to the ballot decision. This round was a unanimous decision with 3 ballots for the defense. Congratulations to both teams on a great round, and congratulations to the defense team who will be advancing to the final round. And I will be sharing the link to the judges' comments and score in the Zoom chat right now. And that's all from me. Thank you so much to everyone.
Great job to both teams. This was impressive. I was not this good in high school. Congrats, prosecution, making this far. Best of luck to defense.
Great job, guys.
Great
Thank you
job.
so much for this round. Thank you for Gilgamesh for a
Thank
great
you.
round. Before you guys go, do you guys want to get a team picture?